Good evening. Welcome to the Osher Lifelong Learning Institute at Berkshire Community College. My name is Carol Allman Morton. We'll get started after just a few announcements. As we begin, with gratitude and humility, we acknowledge that those of us in the Berkshires are learning, speaking, and gathering on the ancestral homelands of the Mohican people, who are the indigenous peoples of this land. Despite tremendous hardship in being forced from here today, their community resides in Wisconsin and is known as the Stockbridge-Munsee community. We pay honor and respect to their ancestors past and present as we commit to building a more inclusive and equitable space for all. To learn more about programming at Ollie at Berkshire Community College, you can see our website at berkshireollie.org. We have a number of programs coming up in the next 2 months, so be sure to look at the Ollie at BCC calendar of events at berkshireollie.org/events. Our next distinguished speaker lectures are February 12th with Amherst Professor Alon Stavins on A Brief History of Love, and March 19th with Mount Holyoke Professor Saren Houston on climate change and human migration. Registration for our spring semester will open on March 5th, and classes begin the first week of April. As we go along, if you have questions, please put them in the chat, and Doug will do his best to get to as many as he can. And now I am going to turn things over to Doug Mishkin, a frequent Ollie teacher and speaker.
Good evening. Some programs begin by saying something like, tonight's topic may seem complicated, but our speaker will explain how actually it's not that complicated. Tonight, no such luck. Tonight, you'll hear about injunctions and grants or denials of stays of injunctions and grants or denials of orders vacating stays of injunctions and emergency grants of certiorari before judgment and GVRs. What are they? Stay tuned. These are all legal procedural matters that can be genuinely confusing to two groups of people who are not lawyers and people who are. Why should anyone care about these things? Because one cannot begin to understand what's going on these days in the Supreme Court of the United States without understanding these matters which routinely get adjudicated on what has come to be known as the Supreme Court's Shadow Docket. Our guest tonight is genuinely uniquely qualified to help us understand. Professor Stephen Vladeck holds the Charles Allen Wright Chair in Federal Courts at the University of Texas School of Law. He's a nationally recognized expert on the federal courts and constitutional law, among other things. He's argued before the U.S. Supreme Court and the Texas Supreme Court and has testified before numerous federal and state legislative bodies and agencies. He's received numerous awards for his legal scholarship, prolific popular writing, his teaching, and his service to the legal profession. Many of you have seen him on CNN, where he is their Supreme Court analyst. I trust many of you read his op-ed in yesterday's New York Times about the Texas border dispute. He is the editor and author of One First, a terrific weekly newsletter about the Supreme Court. But his estimable bio does not include the activity by which I first became his student, namely his appearances on the podcasts of the National Constitution Center, a treasure trove of teaching about the Constitution. Professor Vladeck joined the University of Texas faculty in 2016 after 11 years teaching at the University of Miami School of Law and the American University Washington College of Law. He is a self-described native New Yorker and hopeless New York Mets fan. Is there any other kind? But most to the point for our purposes, he is the author of the New York Times bestselling book, The Shadow Docket: How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic. That is a loaded title, and the book backs up every word of it. Steve Vladeck, welcome. Thanks for being with us.
Thanks, Doug. It's great to be with you.
Let's get down to it. What is the Shadow Docket?
Yeah, I mean, so it's an umbrella term that was coined in 2015 by a conservative Chicago law professor named Will Bode. And it's really just meant to capture really the thousands of procedural orders that the Supreme Court issues every year that are, Doug, as you know, by tradition, unsigned. They're usually unexplained. And although many, if not most of them are, fairly routine and or anodyne, some of them aren't. And so Will was using the term basically to set apart the shadow docket, which is actually most of what the Supreme Court does, from the merits docket, which is actually just a small slice of what the court does. But those are the 60-ish cases that the court hears oral argument in each term, that it gets multiple rounds of briefing in, that it hands down these lengthy opinions about. And Will's insight was that, like, yeah, that stuff's important, but so is all the stuff that happens over there where no one's looking. And so the term really is basically this evocative shorthand for all the stuff the court does in the metaphorical, if not literal, shadows.
And so on the merits docket, where you say a decision ordinarily results in a decision of one length or another, how does a shadow docket matter get resolved?
Yeah, I mean, so the typical, shadow docket matter really falls into two categories. So these days, by volume, the most common order resolving a case in the Supreme Court is a denial of what's called certiorari. This is the Supreme Court saying, we are not going to exercise our discretion to take up your appeal. And that's the fate by which 97, 98% of appeals die in the Supreme Court. And those, Doug, as you know, are just one sentence, sometimes 9-word orders that just say the petition for a writ of certiorari is denied. No explanation, no rationale, no nothing. We also have this other subset that's become much more active lately of a set of cases where parties, before that case gets all the way to the Supreme Court, are asking the justices to intervene to adjust the status quo. So, hey, Supreme Court, we'll be back in a couple of years. Until then, we'd like you to freeze this policy or unfreeze this policy. And those orders come under the shorthand of emergency applications. And what's remarkable, Doug, is those two, at least lately, tend to be unsigned and unexplained, even when the court is granting them, and thereby upsetting the status quo, thereby sometimes producing massive real-world effects.
So the book is chock full of examples, and we'll be digging into them shortly. But I want to take you, or get you to take all of us to the introduction in your book, because the introduction sets the stage with a magnificent story. It's August 2nd, 1973. You put us in a summer cottage in Goose Prairie, Washington. Why? Because that's where Justice William O. Douglas was when he, in your words, set in motion one of the strangest proceedings in the history of the United States Supreme Court. Tell us about the case of Holtzman versus Schlesinger.
Sure. I mean, so this was, the summer of 1973. The war, U.S. troops had withdrawn from Vietnam, but there was still conflict in Southeast Asia. President Nixon, quite controversially, was continuing to bomb communist strongholds in Cambodia and Laos. And there was, at least partly inspired by some of the other Watergate stuff, increasing pushback from Congress, culminating in a funding cutoff that said basically, as of August 15th, no more money to bomb Cambodia. And so Congresswoman Elizabeth Holtzman and a handful of Air Force officers brought a lawsuit against Secretary of Defense James Schlesinger, arguing that the bombing of Cambodia was unlawful even before August 15th. And they brought that lawsuit in Holtzman's congressional district in Brooklyn, where it was assigned to Judge Orrin Judd. And Judge Judd issued this remarkable and unprecedented injunction where he said, I agree with the plaintiffs, and I am, issuing a pause of any further military operations on or over Cambodia. Doug, still to date, the only injunction against a military operation in American history. The federal government was none too pleased with Judge Judd's order, and so they quickly obtained a stay, that is to say, an emergency order freezing the effect of the injunction, so allowing the bombing to continue, from the Federal Appeals Court in New York, the Second Circuit. From there, Congresswoman Holtzman and the other plaintiffs went to Justice Thurgood Marshall, because Marshall was what we call the circuit justice. He was the one of the 9 justices who had geographic responsibility for New York. And they asked Marshall to lift the stay, basically to put Judge Judd's injunction back into effect. And Doug, as was the norm at this point in the court's history, Marshall was set to do all this by himself. The court was out of session. The justices were scattered to heck and gone. Marshall, it turns out, was in Washington, although he might have been alone. And so Marshall invites the lawyers to come to his chambers, where he has an in-chambers oral argument about what he should do. And he writes this lengthy opinion. He files it on August 1st, 1973, where he says, you know, the plaintiffs have really good arguments that what Nixon's doing is unconstitutional, but my job as a circuit justice is to rule not necessarily the way I want to, but the way that I think the full court would if it were here. And I think the full court would not vacate the stay. I think the full court would leave the stay in place, which Doug, of course, had the effect of letting the bombing continue until the cutoff on August 15th. Normally, that would have been the end of the matter. But Holtzman and her lawyers, who were, the ACLU and some other folks, decided to try this cross-country Hail Mary, where they get on a plane, they fly out to Portland, Oregon, they rent a car, and they drive through the night to find Justice William O. Douglas. Douglas, by this point, is the senior associate justice on the court. He's in his 34th year on the court by 1973. And during the summer, he would just sort of abscond to this cottage up in the mountains outside of Yakima, where he had no phone, where the only way to reach him was to literally walk up to the door and knock on it. And that's what these lawyers did. So they go to Douglas, they knock on the door, Douglas says, this seems interesting. And so he decides to hold a hearing on his own the next day in Yakima. He takes over the federal courthouse in Yakima. He has someone from, the U.S. Attorney's Office come and represent the government. And he holds this argument on Friday, August 3rd in Yakima, at the end of which he decides that he's going to vacate the stay, that he's going to put the injunction back into effect. And so he starts sort of driving back up the mountain to his cottage, stopping at one road stop after another. And if you talk to his clerks from that term, what they tell you is they would all get on the phone and they would all take a transcript so that, like, when they reconciled the transcripts, they'd get pretty close to what he had been dictating. So Douglas basically dictates this opinion over the phone to his clerks, which they file on Saturday morning, August 4th, putting the injunction back into effect. Well, the federal government was ready for this. So the federal government goes back to Marshall and says, look what your brother Douglas just did. And so they ask Marshall not to reverse Douglas. Marshall can't, right? All Douglas did was vacate the stay. There's now no, sort of thing for Marshall to act on. Instead, they ask Marshall to issue a stay of his own, basically to freeze the injunction on his own authority. And Marshall does this remarkable thing where not only does he do this, but he actually called the other 7 justices and got them all to basically allow him to say that he had consulted with them and they were on board with his actions. So basically, he sort of, overruled Douglas by fiat. Douglas files a lengthy dissent where he complains about this sort of short circuit process and how it wasn't any way to run a railroad and how the court didn't even have a quorum. I mean, he throws a lot of arguments in there. But Doug, it was really this sort of unique example of what had been a very stable process at the court for dealing with emergency applications that fell apart because of how bitter everyone was about Vietnam and Cambodia and all that related politicking and legal issues. And it helps to precipitate this shift in the court's procedures to prevent future Douglases from pulling a Douglas, where now, and really ever since 1980, if the court gets a divisive if any one justice gets an application that they think 2 of the justices might divide over, they refer it to the full court. And they refer to the full court without oral argument, and they refer to the full court without briefing, and the court will usually resolve it without an opinion so that it's more justices voting, but much less process and much less explanation, all because of this one crazy case in August of 1973.
Right. Well, you've probably succeeded in getting a whole slew of people watching, scratching their heads saying this is a crazy way to run a railroad. I thought also part of what made it fascinating was Justices Douglas and Marshall, ordinarily one would have thought of as being at least ideologically attuned, but I mean, so I use this with my students to say, it's 2 different models of judging, Doug, right? So Marshall's model of judging is I am one member of a 9-justice court,
and my responsibility is to do what I think my court will do.
Yes.
And Douglas's model of judging is, I'm a judge, I'm allowed to have my interpretation of the law, whether or not other people agree with me. And, there's a lot to commend both of those models.
So you use the story to set up the rest of the book. And I note that you pointed out that, moving fast forward, during Chief Justice Roberts' first 15 years on the bench, the court issued 4 injunctions pending appeal. What happened when Justice Barrett joined the court? Can you put this into context for us?
Yeah, I mean, starting with the story of the Cambodia bombing case, in one sense, might lead you to think, oh, this is always how the court has always blown up over emergencies. And in fact, the Cambodia case is really an outlier. I mean, you cannot find another example, until, gosh, the last 7 or 8 years, where you had an emergency application that divided the justices quite so in a non-death, well, I know we're going to talk about the death penalty, but in a non-death penalty case. One of the things that has really shifted on the court is not just this move that we mentioned starting in 1980 toward having the full court handle more and more of these applications, but toward granting relief that the full court has historically been very loath to grant. So in the Cambodia case, what everyone was fighting about was this injunction issued by this judge in Brooklyn. Should we let that injunction be in effect, or should we stay it? And no matter what you think about that case, it was the Supreme Court acting against a lower court. An injunction pending appeal is different. An injunction pending appeal is when you, a plaintiff, ask a court to block some government policy, a state COVID mitigation measure, a federal immigration policy. And the lower court says no. And so when you appeal, nothing is blocked. When you appeal, the status quo is as it was before you walked into court. An injunction pending appeal is asking the appellate court, whether it's the intermediate appeals court or the Supreme Court, to do what the lower courts refused to do, which is to say, to block this preliminarily for the duration of the case. And so historically, the Supreme Court has been really, really reluctant to do that on the grounds that that's usurping the prerogative of the lower courts, that, the Supreme Court gets the last word. No one disputes that. But for the Supreme Court to issue injunctions pending appeal is basically for the justices to, transform themselves into a trial court. Like, hey, we're going to, come right to us and we'll figure it out. And that's part of where that data point comes from, that, over the first 15 years of John Roberts' tenure, the court issues 4 of these injunctions. During the first 6 months, Justice Barrett is on the court issues 7 of them. And, that's partly a reflection of the change in composition of the court, obviously. But even before she joined the court, you saw more and more justices voting for these, so that they were losing, but they were losing 5-4. So one of the things the book really tries to document is how, starting in the mid-2010s, you have this convergence of a series of factors where you have justices who are more willing to grant these kinds of interventions than anyone had been before, where you have, in the Trump administration, a federal government more willing to ask for these emergency interventions than at any point ever before. And where you have, I think, really unfortunately, lawyers on all sides seeing both of those things happen and deciding that it's open season. And so now it's not just that the court is doing this more and that the federal government's asking the court to do it more, it's that now everyone, right, is coming to the Supreme Court to jump in. Doug, a week into a case, 2 weeks into a case, on the theory that once they've crossed that line, why not me? And so I know we're going to get there, but last Friday is a great example. Last Friday, the Supreme Court issued an unsigned and just about unexplained order, turning away a request from the plaintiffs in last year's affirmative action cases, the plaintiffs who had challenged racial preferences successfully at the University of North Carolina and Harvard, who are now challenging racial preferences in the US service academies, which the majority opinion from the Supreme Court last year had weirdly carved out. But Doug, the case is not over. The case just started. And after the district court in New York said, I'm not going to issue an injunction yet, the plaintiffs appealed. And while they were waiting for the appeal, they asked the appeals court in New York to issue an injunction pending appeal. And the appeals court said, no, not yet, right? Too early. And so they went to the Supreme Court. And, yes, the Supreme Court said, no, it's too early. But Doug, 10 years ago, it would never have even occurred to those lawyers to try, because the notion that the Supreme Court even could be talked into intervening at this early stage of a case with this dramatic emergency relief would have struck people as completely nonsense versus what we've seen since 2016.
So we're talking largely about the court exercising discretion. And in the first formal chapter of the book, you give us an extraordinary history lesson, and you tell the story of the president who arguably had the greatest long-term influence on making the Supreme Court what it is today, but he didn't do it while he was president. Please explain.
Yeah, so it turns out the hero or the anti-hero of our story, depending upon which side you want to take, is William Howard Taft. And Taft, I think the historians would say he was a fairly middling president. But I think not everyone realizes that after he was president, he was Chief Justice. And he was Chief Justice not just at this remarkably transformative period in the Supreme Court's history, but also in ways that transformed the court. And the ways that he did that were, Doug, twofold. First, he said, and this is sort of obvious in retrospect, we have to get out of the Capitol. Right until 1935, the Supreme Court literally sat in the Capitol. And Taft says, not totally unpersuasively, how independent and autonomous a branch can we be if we're depending upon Congress to turn the lights out?
And by Capitol, you mean to say the actual U.S. Capitol building?
Yeah, yes, the Capitol with an O, right? That the Supreme Court was in the basement of the Capitol till 1860. They were in the old Senate chamber till 1935. So Taft's first big thing is let's get our own building, which was toward establishing the independence of the court. But his second thing is much nerdier, but in some respects, Doug, much more important. Taft wanted to transform the court's docket. So as late as 1891, 102 years into the Supreme Court's history, the court had to hear every single case that it had jurisdiction to hear. It had no control over its docket. Congress dictated everything the court did. And that meant, after the Civil War, with the explosion of federal law, the federal government, federal courts, by the 1880s, there were some 1,800 cases on the court's docket at any one time. The justices are like 3.5 years behind. And Taft says, this is no way to run a Supreme Court. We're the Supreme Court. We're not just a podunk little court of appeals. If you really want us to be supreme, if you want us to be on par with the other branches of government, we should get to pick and choose our cases. And so Taft was the earliest and the loudest and the most significant lobbyist for the rise of this thing called certiorari, this Latin term that basically just means giving the justices control over their docket. And he works at this both before he's president and after he's president. Finally, when he's Chief Justice starting in 1921, he pushes Congress aggressively to give the court, he wants complete control, right? But this is my 5-year-old torturing me with ice cream. He wants complete control over the docket. Congress gives him sort of partial control over the docket. But Doug, the reason why he wanted control is because from his perspective, the court was supposed to be above and apart from the fray of ordinary judicial business. And the justices, if they could pick and choose the cases they were deciding, could function much more like a constitutional court as opposed to just a Supreme Court of Appeals, right? So the goal of certiorari was to give the justices more power, and power through discretion, power to decide which cases they're going to hear, which questions they're going to decide within each case. And what's remarkable, Doug, is just how today we assume that's how it always was, right? Today, the Supreme Court's docket is almost exclusively discretionary. Last term, the Supreme Court decided 58 cases on its merits docket. 57 of them were cases the justices chose to hear. And that has enormous consequences for the court's power. Doug, it has enormous consequences for how we think about the court's decisions as a data set. Excuse me, Sid, right? And it really just, I think, like, is something we don't teach enough to folks about how certiorari gives the court power and control in ways that really put what the court does into context.
Steve, you point out that it became not just the discretion to decide what cases to take, but which questions to address within those cases. Can you explain to our listeners what it means to say the question presented in a cert petition?
Sure. Sydney, hey, can I finish? So the idea behind the sort of the power to control which questions they heard is usually in the English practice, as my 5-year-old is an expert on, the idea was that when you grant a writ of certiorari, you're taking the whole case. And so that means that you actually have to decide all of the questions in the case. About 3 years after Taft convinces Congress to give the court control in the Judiciary Act of 1925, what's known as the Judges Bill, the court also starts basically saying that we can also grant certiorari only on individual questions. So basically, even Doug, if the case has 4 issues in it or 6 issues in it, and some of those would allow the justices to avoid the biggest constitutional question, the court can choose just to take the question they want. Later, right, starting in the 1960s, the justices take that one step further, where not only are they only going to grant a question, but Doug, sometimes they're going to write the question and then grant it. So if they don't like how the parties have presented the question, they'll write it themselves. And I think what that really drives home, Doug, is just how much control certiorari gives the court to decide what it's going to decide. This may seem like a small point, but guys, when we think about media coverage of the Supreme Court and stories that like the court was unanimous in 28% of its cases, or justices so-and-so agreed or disagreed in X% of cases, no one ever sort of reminds you that the justices picked the cases, right? That the denominator was controlled by the court. Statisticians would call that selection bias. And that's, what that really drives home is like, the court has all this power today, Doug, because Congress gave it to them. And as they claim more and more power, including the question selection power, Congress never took it back. Right? Instead, Congress just kept giving the court more and more power, culminating in 1988, when Congress took most of what was left of those cases the court had to hear and said, no, justices, you decide.
So, Steve, I'd like to get you to tell the story that you tell in the book about an important case that the court chose not to take. In 1954, the court decides Brown versus Board, a big deal in many ways. And 2 years later, a case comes to the court out of the state of Virginia, where there had been a challenge to Virginia's anti-miscegenation statute. And the Virginia state courts had rejected plaintiff's federal constitutional claim. And you point out, this was the kind of appeal, it was well within the court's mandatory appellate jurisdiction. But the court declined to hear this case, Name, N-A-I-M versus Name. And now it's part of Supreme Court lore that Justice Tom Clark was reported to have said in explaining why the court declined to take Name versus Name. What did he say?
One bombshell at a time is enough. And I think, what that really drives home, Doug, is, it cuts both ways. If, right, in a world in which the court's docket was completely controlled by Congress, a decision like Brown versus Board of Education would have required the justices to take hundreds of follow-on cases in which they would have had to answer really hard questions. For example, right, is Virginia's anti-miscegenation statute unconstitutional? They'll answer that eventually in 1967 in a case called Loving versus Virginia, right? So you could argue that certiorari actually helped to facilitate the Warren Court, because now the court could issue these bombshells and not have to pay the price, which might otherwise have disincentivized the court from issuing those first decisions. Another great example is in applying the Bill of Rights to states, right? So if the Supreme Court in 1963 says, oh yeah, local and state police officers and not just federal police officers are bound by the Fourth Amendment, they don't have to worry that that decision is going to create thousands of cases for them to handle because they can deny discretionary review in all of them. And so it's not that this power is nefarious. I mean, one of the things that happens a lot with my book is folks assume that I'm like anti all of this. I'm not. I just want us to understand that this power is power and that this power actually has massive ramifications for understanding what the court does today and for understanding how, if you think that what the court's doing today is problematic, we could begin to even think about digging ourselves out of it. Yeah.
So let's begin to dig in on how the court has exercised its discretion in some specific sets of cases. And I want our listeners to know that you, in the chapters that follow, you essentially address 6 categories of cases. There's the same-sex marriage cases, death penalty cases, Trump's travel ban and related policies, so-called religious liberty cases, and then there are the election cases, and finally the abortion cases. We can't possibly dig into each topic tonight, but with a little bit of method to my madness, I want to ask you to address 3 of them. And let's begin with your chapter 2, which you entitle Substance in Procedure, How the Court Decides Without Deciding. And this is the chapter where you talk about the same-sex marriage cases. And you set the stage. It's June 26, 2015. The court decides Obergefell versus Hodges by a 5-4 vote. And the Supreme Court said that state bans on same-sex marriage violated the Due Process Clause of the 14th Amendment. And you point out that decision legalized same-sex marriage in 13 states. But you then say that by this time, same-sex marriage had been legalized already in 37 states, plus the District of Columbia and Guam. How did that happen?
Yeah, I mean, this is one of the, it's another example of how there's so much daylight between how we tend to talk about the Supreme Court and what's actually happening on the ground. So the short version is the number 37 breaks into 2 categories. There are 19 states, including Massachusetts, that legalize same-sex marriage on their own, whether through legislation or state ballot referenda or decisions of the state Supreme Court on state constitutional grounds. But there are 18 states, Doug, in which same-sex marriage became legalized because lower courts blocked the state's marriage ban, the state appealed, and the Supreme Court denied certiorari. The Supreme Court exercised its discretion that we were just talking about to not even take up the state's appeal. And you can draw a straight line, and the book draws a straight line from 7 denials of certiorari in October 2015 to those 18 states. And basically 18 states where within days or weeks, or in one case, 2 months, same-sex marriage became legal before Obergefell, before the Supreme Court's big, much ballyhooed decision. What that drives home, Doug, is sort of 2 things. One, the Supreme Court is adamant that when it denies certiorari, when it refuses to take up an appeal, no one should take that decision as having any precedential value. It is not a comment about what the justices think of the merits. It's not a reflection of how they're likely to rule if they heard the merits. Fine, but there can still be massive real-world effects, right? Because part of what the court's doing in those cases is leaving intact lower court decisions, Doug, that produce real-world effects. And so right, that's how you get to, so that's the first point, is that, denials of certiorari may not be legally precedential, but boy, can they create some significant real-world effects. The second point is it's now pretty clear. I mean, it takes 4 justices to grant certiorari. So we know that there were no more than 3 votes, right, in those earlier same-sex marriage cases for the court to take them up. But we also know that in Obergefell, 4 justices dissented on the ground that they thought these state marriage bans were constitutional. Well, it turns out that Chief Justice Roberts voted to deny certiorari even though he would subsequently say that those lower court decisions were wrong. He was willing, basically, to have same-sex marriage be legalized through these denials of certiorari, through these lower court decisions just spreading without the Supreme Court ever having to step in. And the only reason why his hand was forced is because a very prominent conservative judge on the Sixth Circuit, that's the Cincinnati Federal Appeals Court, called the court's bluff and said, you may think that it's clear what you're doing, but I don't know what you're doing. And so he wrote an opinion upholding marriage bans in Michigan and Ohio and Tennessee and Kentucky, basically forcing the Supreme Court to step in. That's Obergefell. And that's how we get to the last 13 states.
You make a fascinating point, and this, if our listeners think we're down in the weeds, you ain't seen nothing yet. You talk about what became Obergefell, the cert was granted, but even after that, there was an unsigned order legalizing gay marriage in Alabama. And Justice Thomas dissented, and then there is a sentence that one will not find frequently in your book where you say, on this point, Justice Thomas was clearly correct. Tell us quickly what you're talking about there.
So, by the time the Alabama case gets to the Supreme Court, the court had already said, we're going to take up these cases from the Sixth Circuit. We're going to take up the Michigan and Kentucky and Ohio and Tennessee cases. And Justice Thomas says, listen, before we just agreed to take up these cases, you could have sort of justified our non-interventions, right? You could have, as saying like, well, it's not clear the Supreme Court's going to step in, and so we don't have to freeze these lower court orders. And what Thomas says is the fact that you're letting Alabama's order, the order basically blocking the same-sex marriage ban in Alabama, allowing same-sex marriage, the fact that you are allowing same-sex couples to get married in Alabama, even though you already agreed to resolve whether this whole thing is constitutional, doesn't make any sense, Doug, unless they had already made up their minds about what they were going to do, right? So, the Alabama order I realize that these are a lot of weeds, and I realize that like a lot of the folks who we're talking to tonight aren't lawyers. The point of the book, guys, is that the weeds matter. And like to really understand the Supreme Court today, we actually have to spend more time in the weeds, because sometimes, as in Obergefell, the weeds are where 18 states legalize same-sex marriage. And again, Doug, to go back to something I said a minute ago, this is not necessarily nefarious, right? I mean, we might be very, very happy with how the Supreme Court went about legalizing same-sex marriage. The point is that like one who thinks that all the Supreme Court had to say about marriage was what it said in Obergefell is missing so much of the story, and like all of the ways in which the court actually tried to resolve the issue without resolving the issue in ways that had to have lots of interesting lessons to tell us about not just who the justices are, but the future of litigation of those issues before this court.
Before we move on to the next category of cases, I just want to get you to comment. You point out in this chapter, we talk about defensive denials, and Justice Roberts engaged, Chief Justice Roberts engaged in that practice. But after Justice Kennedy retired, there were instances where the then 4 liberals on the court essentially did the same thing, namely refusing to, deciding not to grant cert because they may have had 4 votes for cert, but they weren't going to have a majority and they didn't want to make more bad law, right? This goes both ways, yes?
Yes, and the reason why it matters, Doug, is because we tend to assume that the Supreme Court takes any sort of like big, significant constitutional case or even a big statutory case. And the reality is actually very different. That the justices sometimes stay away from cases because maybe they don't want to have to take a position on an issue. Maybe their political preferences are inconsistent with what they think the right legal answer is. And so denying review allows them to avoid having to reconcile their preferences. There are lots of explanations for this. There's a ton. The larger point is that this entire process, the entire sort of edifice of certiorari creates all kinds of room for both strategic and tactical behavior by the justices, by litigants, by lower courts, by government actors, behavior, Doug, that is very much, how do I say, I mean, I think I say this in the book, lends itself to the rise of this technocracy, where you really do get, folks who are experts on the norms and the unspoken rules of how the Supreme Court operates, that in turn really sort of crowd out other parts of the, the legal structure. I mean, just one really small point on this. The Supreme Court, with all this discretion, Doug, has actually been deciding fewer cases every year. I know it doesn't feel like that to most of us, but over the last 5 years, the court has decided the fewest cases since any point at any point since the Civil War. You might say, well, wait a second. I can name a bunch of cases the court does. Yeah, they're deciding fewer cases, which means both more of their decisions are these big headline grabbing cases, and the cases that are getting left behind are cases other lawyers might care about, but aren't necessarily these big socially divisive culture war or political war disputes. Just to take one example, last term of the 58 cases the court heard, one was a direct appeal from a criminal conviction in a state court. One. That used to be the court's bread and butter, and it's totally disappeared from the court's docket in ways that, if you don't look at the court in this holistic way, we totally don't appreciate.
But toward the end of this chapter, you make the observation that what the marriage cases underscore is that there are circumstances in which whether the Supreme Court allows a challenge law to operate while the challenge works its way to the justices can be just as important as, if not more important, than how the court ultimately resolves that challenge. Then you say, and this is our segue to the next group of cases, this started not with marriage, but with death. And the next chapter is you entitled The Machinery of Death, How Capital Punishment Gave Rise to the Modern Shadow Docket. And if you would, I'd like you to start, as you do in the chapter, by telling us quickly about the story of the case, the 1942 case, Ex Parte Quirin.
Oh man, I mean, this is, anytime you have Justice Scalia calling a case, quote, not this court's finest hour, unquote, it's going to be a good story. I don't want to get too far. I mean, we could do an hour just on Quirin. The short version is that the Supreme Court did not exactly cover itself in glory in how it dealt with these really bizarre cases in 1942 about FDR's attempt to use a military commission as opposed to a civilian court to try 8 Nazi saboteurs who had snuck into the United States ostensibly on a mission of industrial sabotage. Doug, it turns out like at least 2 of them wanted to turn themselves in and like were trying to almost defect. So the court twists itself in a pretzel basically to allow this military commission to go forward. And it hands down this very cryptic order that says, hey, military commission, do your thing. We'll file an opinion later explaining why this is kosher. And so the military commission does its thing. It convicts the 8 saboteurs. 6 of them go to the electric chair. FDR commutes the sentences of the 2 who actually tried to turn themselves in. And that's in August of 1942. Then the court comes back in October and tries to write an opinion and finds that actually they're not really sure why the military commission was kosher. And so this leads Justice Frankfurter to write one of the more macabre internal memoranda in the court's history, where he basically sort of takes on the personage of the since executed saboteurs and chastises the court for a hypothetical fractured decision that actually, gives credence to the war effort, empowers the enemy. Like he basically tries to cower the other justices in a submission. And the moral of the story that we're supposed to take away is like, hey, it's not a good idea to execute first and write the opinion later. Like maybe you should write the opinion first. And for generations, Doug, that's the mantra that the court takes to capital cases. So, when the court reinstitutes the death penalty in 1976 with a whole bunch of new constitutional rules, like the death penalty is constitutional if these 11 boxes are checked. Well, those 11 boxes have to be litigated. And so the court really gets into the habit of pausing executions to allow those 11 boxes to be litigated, starting in the late 1970s, early 1980s. But two things happen, right? One, the court moves further and further to the right with less and less patience for those 11 boxes, where there's more and more sort of lack of interest in freezing executions, where the justices become persuaded that this is just litigation tactics by capital lawyers, not really meritorious claims. And two, Congress comes along in 1996 and imposes additional obstacles on the relief that courts can provide in those kinds of cases, so that by the time Justice Kennedy retires in 2018 and is replaced by Justice Kavanaugh, Doug, there are now 5 justices who believe that, in general, there shouldn't be last-minute relief in capital cases. And that basically, no matter who's responsible for the delay, any 11th hour appeal in a capital case comes to the court with a presumption of lack of merit. And so we've seen since 2018, and especially since Justice Ginsburg died in 2020, that the court in capital cases now is basically just clearing the way for executions that lower courts have blocked. The court has intervened, I think, Doug, twice in the last 3 years to block an execution. Once it was in this bizarre Texas case about having a religious officiant in the execution chamber. The other was when the state agreed that the execution should be blocked. That's in the Glossop case out of Oklahoma. Otherwise, I mean, the quote that I use in the chapter is from Justice Blackmun. And Blackmun said, one day in the late 80s, late in his career, Blackmun says, I'm tired of the death penalty. Like, this tinkering with the machinery of death is not something judges should be doing. He meant that as an encomium against capital, but he said we should be, we should just stop doing this. And the current court has stopped tinkering with the machinery of death, Doug, by basically doing whatever it can to clear the way for executions, almost in the opposite of the Frankfurt mold. The reason why the Curran story is so apropos is because now the court's mindset is, as long, even if there are open questions about your legal claims, even if there's a chance you might win, unless you can persuade us that you're going to win, we're going to let the execution go forward, which is just such a complete inversion of, the sort of the lesson that we had originally taken from that Nazi saboteurs case.
The chapter is chock full of discussions about particular cases, but I want to ask you to tell the quick story about the case that gave rise to the New York Times editorial that was entitled, quote, "Kill him, 4 to 4, end quote." What gave rise to that?
Yeah, I mean, so it's interesting because if you talk to folks who worked at the court, practiced before the court in the 1980s and the 1990s and the 2000s, you ask them about the Shadow Docket, what they'll talk about is death cases, because that was the overwhelming majority of what the court did in the shadows. The 4-4 case arose from this bizarre compromise that the court reached in the mid-1980s. So I mentioned it takes 4 votes to grant certiorari. That means it takes 4 votes to agree to take up an appeal. It takes 5 votes to issue a stay. And so you had this unseemly prospect that 4 justices, and there at the time were 4 who were pretty hardened against the death penalty, would agree to take up a prisoner's case, but they couldn't get a 5th vote for a stay, and so the prisoner would be executed while his case was sitting on the Supreme Court's docket. This didn't look very good. So Justice Lewis Powell, who was, by any definition of the term, a Virginia gentleman, inaugurated this practice of the so-called courtesy 5th, where whenever 4 justices voted for certiorari in a capital case, he would provide a 5th vote for a stay as a courtesy to make it possible for the court to perfect its review of that case. Well, in the case that produced the ugly headline, Powell was sidelined because he had a medical procedure, actually a very serious one, in which he nearly died. And so he was unable to vote. And the court's voting rules being what they were, unless there was a 5th vote for the stay, there would be no stay. So the court voted 4-4 to grant certiorari and deny the stay, and the prisoner was executed. And that is just, how macabre this all became by the mid-1980s.
Before we move on, I want to get you to say a word about you say between 1963 and 2020, there were a total of 3 federal executions, and then 6 months under President Trump, there were 13. And you say all 13 were cleared by shadow docket rulings. Can you say just talk for a moment about that?
Yeah, I mean, so most of the time when we talk about the death penalty, we're talking about executions by states, and by the handful of states that still have robust capital regimes. Texas is one of them. I mean, Texas, I think, is actually by far the clubhouse leader. The federal government, Doug, is not usually involved in executions because the federal death penalty has its own series of rules. And for various reasons, federal courts have historically been reluctant to impose death sentences. President Trump and especially Attorney General Barr really wanted to do something about this. So they went through Herculean efforts starting in late 2019 and early 2020, basically to clear federal death row, and to carry out executions of as many of the federal prisoners under death sentences as they could. What's remarkable about this is, unlike, Doug, the typical state cases where you have this long buildup, you have a series of, years-long litigations, and you have, in some cases at least, understandable frustration with how long it's taking. In the federal cases, right, it was the federal government that was rushing. And so you had federal judges in Washington, D.C. and in Indiana, not exactly hotbeds of liberalism, right, slowing things down and saying, whoa, federal government, like, we got to make sure these procedures are kosher. We've got to make sure you dotted your, I mean, these are capital cases. And starting at 2:10 in the morning, one night in July 2020, the Supreme Court started clearing the way for these executions. There were 13 federal prisoners executed between July 2020 and January 2021. The court intervened at some point in all 13 of those cases. And in 7 of the 13, like, there are 7 prisoners where you can specifically point to decisions where the Supreme Court wiped away lower court stays of execution. So basically, it's not just that these prisoners were asking the court to intervene, it's that the federal government was asking the court to clear the way for executions that lower federal courts had blocked. And in some of those cases, the rationales, such as they are almost indefensible.
I just want to say to our participants tonight, this chapter, like the others, has so much more that is chilling about this, regardless of what one feels about the death penalty. But I do want to move us along to another one of your chapters where you talk about the election law cases. Chapter 6 is entitled The Purcell Principle, How the Current Court Uses the Shadow Docket to Help Republicans. I want to note quickly, you begin with a great story that all political junkies love about the 1948 primary election that put Lyndon Johnson into the United States Senate by 87 votes out of nearly 1 million. The story of Box 13, all you Robert Caro fans, you would love this, and there were emergency Supreme Court rulings involved. We don't have time for it tonight. Read the book. Professor Vladeck, what's the Purcell Principle?
So the Purcell Principle is named for a 2006 decision that the Supreme Court handed down on the shadow docket. That is to say, without full briefing, without oral argument. This time, at least, Doug, they wrote an opinion, but the opinion raises more questions than it answers. And the basic idea behind the Purcell Principle is unobjectionable enough. The short version is, hey, federal courts, if there's about to be an election, don't issue a court order that's going to make it hard for people to vote, right? Don't issue a court order that's going to confuse people. That even if the rules are wrong, we would rather have clear rules that are wrong than unclear rules that are right. And if you frame it that way, Doug, it actually, I think, is really hard to, argue against it. Like, yes, right? I mean, confusion at the polls is not something we should be promoting. The problem is not the principle. The problem is how it's been applied. And it's been applied in ways that are, as the book documents, perhaps the most problematic subset of shadow docket cases, because it's the subset in which the court looks the most partisan. What I mean by that is that there are, if you look at the, sort of the 2020 election cycle, when there was an unusual number of these cases because of COVID. COVID had two effects, right? One, well, it had lots of them, but it had two relevant effects. Relevant effect number one is you had a lot of jurisdictions that tried to change their voting rules to accommodate the challenges posed by COVID. And then two, you had some jurisdictions that didn't change their rules where litigants sued, arguing that the rules ought to be changed to accommodate the problems of COVID. You had an unusual number of these cases. And a number of lower courts stepped in and said, yeah, we don't want you to have to get 3 witness signatures on your absentee ballot, because otherwise you'd have to go into strangers' homes while there's this, transmissible virus out there. Like, that's a bad idea. Or yes, we're okay with having absentee votes that come in late as long as they're postmarked by the right date. I mean, there are lots of these cases. And the court would intervene in some of them, but not others. And the only pattern that really explains the intervention is they intervened when it was good for Republicans and they didn't intervene when it was good for Democrats. And I've been doing this for a couple of years now. I've been writing this critique. No one has ever provided a satisfying response that explains the pattern. But where it really gets worse is in the 2022 redistricting cases. So, folks might have some loose familiarity with these cases. So Alabama redrew its 7 congressional districts after the 2020 census and only created a single so-called majority-minority district, even though the population of Alabama is 27% Black, which means, and not just 27%, but 27% that is geographically compact, which means under the Voting Rights Act, they're entitled to a second majority-minority district. 2 different lower courts said, yes, Alabama, go back, redraw your maps. And they said this in January of 2022, Doug, 10 months, right, before the November midterm election. And the Supreme Court steps in without any explanation and issues a stay, and allows Alabama to use these maps that lower courts had struck down. The only opinion is a concurrence by Justice Brett Kavanaugh, where he cites Purcell. He says, it's too close to the election. It was 10 months till the election, right? The other problem is that when that case came back to the court, Doug, last year, the court agreed with the district court and said, yeah, you were right to block the maps. So what you have in Alabama is you have the Supreme Court's unsigned, unexplained order clearing the way for a House seat that probably should have been not just a majority-minority district, Doug, but probably a safe Democratic seat, that instead was a safe Republican seat. You have another similar ruling in Louisiana with the same effect. You have lower courts in Georgia, South Carolina, and Ohio that all said we would have ordered another majority-minority district, but the Supreme Court just blocked Alabama's. Doug, that's 5 seats in the House in the current Congress. That is the Republican Party's current margin of its majority in the House, right? Those cases come out differently. It's distinctly possible that the Democrats have a majority in the House.
In the book, where you note Justice Kavanaugh's concurrence, you said that Justice Kavanaugh said about Purcell, namely this per curiam unsigned decision, that it is a, quote, bedrock principle. You were underwhelmed by that logic of Justice Kavanaugh.
Well, it's not logic; it's ipsy dixit. I mean,
there you go.
If you look at, Justice Kavanaugh really likes Purcell. I mean, every time he writes about Purcell, the adjective in front of principle becomes a little more firm. So, for a time it was a venerable principle, and then it was a important principle. Now it's a bedrock principle. It actually is a very malleable principle that just allows the court to engage in all kinds of mischief.
And to your point that that's at the heart of the book, whatever adjective one wants to use, it didn't come from a merits decision.
Right.
Right. So, all right.
And just, I mean, Doug, just to drive the point home, right? I mean, these cases obviously have enormous consequences, and yet we don't talk about them the same way that we talk about, the affirmative action cases or abortion cases. And I just think that, like, if I persuade folks of nothing else tonight, hopefully I persuade you that talking about the whole court, including all of its docket, is actually critical to understanding all of the ways in which it's currently affecting us, for better or for worse, and maybe some of it's for better.
So I have, we've done the speed dating version of discussing cases under those particular chapters, but I want to allow our participants tonight to observe, in a manner of speaking, a debate between you and Justice Alito. In the book, you report about a speech that Justice Alito gave at the Notre Dame Law School in September 2021 entitled The Emergency Docket. And at this point, Justice Alito was defending the court's use of what we refer to as the Shadow Docket. You take us through 4 principal defenses that he gave. So I want our audience to hear what Justice Alito said and then give you the opportunity to respond as you do in the book. Justice Alito said, first, with respect to he called the emergency docket, first, nothing meaningful had changed. The uptick in volume was because the court was receiving more requests than it had in the past. Professor Vladeck.
So one, as a matter of fact, that's not true. But two, that the court is receiving more requests should not automatically mean that it's granting more of them. Again, this assumes that there's some like locked in ratio of how many of these cases are going to be meritorious. So, other than sort of being wrong about the data and then making the wrong extrapolation from the data, it's fine.
All right, Justice Alito, point number 2. The court's emergency orders were not merits rulings in form or function.
So, I mean, in form, that's correct. The problem is the function. So, Doug, we just talked about the Alabama cases, where the effect of the court's decision was to let Alabama do the thing that lower courts had said was illegal. Right? In function, that is effectively a merits decision. That case at least went back to the Supreme Court. There are a series of cases where the court on the Shadow Docket struck down COVID restrictions in California, where California says, well, shoot, we're giving up, right? Where the court's interventions through these unsigned and mostly unexplained orders, Doug, were the only thing the court ever said. So hard to persuade me that they're not, at least in effect, merits rulings when they're having the same effect a merits ruling would. That is to say, when they're blocking state or federal policies, never to be further litigated, right? In a way that conclusively resolves the dispute.
Justice Alito, point number 3, these Shadow Docket rulings are not precedents.
I mean, they're not supposed to be precedents. That's true. I'm going to put, let me see, I should have had this ready to go. I want to put in the chat in order that folks can look at for themselves, in which the court treats one of them as precedent. So this is an order from a case called Gateway City Church, which the court decided in February 2021. And as you'll see from the order, the court is blocking COVID restrictions, in this case from Santa Clara County, California, on the ground that, quote, the Ninth Circuit's failure to grant relief was erroneous. This outcome is clearly dictated by this court's decision in a case called South Bay United Pentecostal Church versus Newsom. Doug, if you were to go run down South Bay United Pentecostal Church versus Newsom, you would find no majority opinion. You would find an unsigned order and a series of separate concurrences and dissents. So here is the Supreme Court literally treating an order that had no majority opinion as a precedent and chastising a lower court for not following it. So I would say, like, you can say you're not doing it, Justice Alito, but part of why I wrote the book is because I think when you look at all the stuff together, you see how actually sometimes they are.
Justice Alito, point number 4, he attacked critics of the Shadow Docket for complaining about lack of transparency surrounding Shadow Docket rulings.
Well, so his response, right, which is it's true so far as it goes, right? His response is that the sort of all of the filings are available online and the court's ultimate disposition is available online. And that's true, right? I mean, he's right. But, right, the ultimate disposition usually has no explanation. And so all you're seeing is an order that even lawyers would have a hard time understanding out of context. The ultimate disposition can come down, Doug, at any time of day or night. As I mentioned, one of those death penalty cases in July of 2020 came down at 2:10 in the morning. This is a small point, but I think it sort of drives the point home. It can show up on any one of 5 pages on the Supreme Court's website, depending upon what kind of order it is. And just in general, I mean, the point is like, I don't think it's fair to expect the average, person, even one who cares about the court and follows it, to understand from an order. I mean, look at last Monday's order in the Texas razor wire case, right? Where the court voted 5-4 to vacate a lower court injunction. The Supreme Court's ruling basically allowed the Biden administration to remove razor wire that Texas had placed along the US-Mexico border. The majority didn't explain itself. The dissenters didn't explain themselves. And Doug, everybody reacted to the ruling by assuming it said lots of things it didn't say. I don't know how you can look at the public reaction to that ruling, from which Justice Alito dissented, and say that this is actually transparent.
I want to quote you back to yourself, where you try to summarize your feeling about Justice Alito's criticism. You say, the claim that those trying to document and criticize the use of the shadow docket are seeking to damage the court's independence confuses the symptom for the disease.
That too.
Nicely put.
Thanks. Well, it's easier when you're writing a book than when you're talking live.
There you go. And then again, your assistant isn't there helping you this part. I want to ask you a couple of kind of one-off questions that come from different places in the book. You discuss at certain points the idea that some say that critics of the shadow docket are all liberals or all Democrats. What's your response to that?
It's not true. So the progenitor of the term, Will Bode, is a conservative former clerk for Chief Justice Roberts. Roberts himself has been a critic of the court's behavior. He dissented in the Alabama redistricting cases with the 3 Democratic appointees. He dissented in the Texas abortion case with the 3 Democratic appointees. In one case from April 2022, he joined a dissenting opinion by Justice Kagan that was sharply critical of the 5 other conservatives. So, unless John Roberts is secretly a liberal, I think it's safe to say that there's at least one conservative justice who actually shares in these critiques.
So before I ask you for whatever final thoughts you want to share with us, one more question for you. You have a chapter of the book that's entitled Read the Opinion, but it's not read the opinion, it's quote, read the opinion. Tell the audience what that comes from. So
Justice Barrett gave a speech at the Ronald Reagan Library in April 2022, knowing, right, that the court was about to hand down these controversial decisions on abortion and guns and environmental law. And she says, listen, there's going to be a lot of criticism of us in the media in the coming weeks and months. And she says, don't just assume that we're hacks. She says, read the opinion and decide for yourselves. You may not agree with our principles, but hopefully you will agree at least that they are principles. And this is, Doug, not a new claim. This is historically how the Supreme Court has defended its legitimacy. That its legitimacy comes from its ability to provide principled justifications for its decision-making. Again, not because we'll necessarily be persuaded by the court's justifications, but because we'll at least have evidence that the court is acting judiciously and judicially. And what's so remarkable about the Barrett quote is that 2 days after that speech, the court handed down a 5-4 unsigned, unexplained order, putting back into effect a controversial Trump-era water pollution rule, in which hers was the dispositive vote, and in which there was no opinion to read. And it's just, it's because even the justices get into this trap of thinking about the merits docket as all they do, when there's so much important stuff happening in the, at least, proverbial shadows.
So I trust it's clear to our listeners that I have succeeded in doing an injustice, even to the chapters we've discussed, never mind the ones that we have no time to discuss. So before I wrap things up with a few concluding thoughts, I want to give you the floor to say whatever it is you comes to mind that maybe we haven't had an opportunity to talk about.
So, I mean, there are a bunch of questions. I've been trying to follow the questions in the chat, and we don't have time to sort of get to all of them. I've just posted. I really do think that a bunch of my newsletter entries are getting at some of these questions about the history of the court and how to reform the court. And I hope folks will check out the newsletter. There's both free and paid subscriptions, but there's no obligation to buy. The free subscriptions get you more than half of the content. The biggest theme I see in the questions, right, is sort of like reform. How are we going to reform this, and who can reform it, and what can we do about the Supreme Court? And what I want to say, Doug, is I wrote the book largely to reach not just the folks who are with us tonight, but to change how we talk about the court. Because, when we talk about the court as if all it did was its merits docket, reform will never be possible. Because when you talk about the court only as its merits docket, every conversation is ideologically laced, right? Where, the court is either right or wrong, depending upon whether we agree or disagree with its decisions. And to me, what is really problematic about the court we have today is not who the justices are, even if they're not behaving well. It's not the decisions they're handing down. It is how unaccountable they both are and believe themselves to be, as reflected, among other things, in a quote Justice Alito gave to the Wall Street Journal last summer, where he said, I don't think Congress has the constitutional power to regulate us, period. Never mind that there's a provision in Article 3 of the Constitution that says Congress has the power to, quote, make regulations, unquote, of the Supreme Court's appellate jurisdiction. Never mind that he sits in a seat Congress created in 1837. But this is what's in the zeitgeist, that the court is just not supposed to be accountable because it's independent. And what I want us to all see is that historically, the court was both independent and accountable. And that came from this healthier separation of powers dynamic, where Congress was actually pulling levers to keep the court in check. And what we've really gotten away from in the last 30, 40 years is congressional engagement with the court. So to me, the pathways to reform are through Congress. Now, folks will say, this Congress? And, trust me, I get it. But one of the things that's really striking is how, Doug, when we've talked about the court in institutional terms lately, there's been movement. The court has responded, right, to some of the critiques of their procedural behavior by not doing it as often, by moving cases from the shadow docket to the merits docket, by changing their rules. The court responded to the ethics kerfuffles by issuing this unprecedented code of conduct. Now, to call that code of conduct a half measure is to, really, really insult half measures, right? It doesn't even deserve milquetoast as an appellation, but the fact that the justices felt impelled to respond at all is, to me, the much bigger lesson here, which is public discourse and public engagement and public pressure actually can have an impact when it's not about the court being conservative, and when it's not about the justices being ideological, when it's about what's wrong with the court as an institution. And I realize that that's not going to seem satisfying to a lot of the folks who are with us tonight. But from a sort of long-term separation of powers perspective, I think it's much healthier. And I think it's at least a place to start the conversation, even if it's not the place to end it.
Well, I'm going to offer a few brief remarks to end this conversation this evening. And let me begin by saying, Professor Stephen Vladeck, thank you for being with us tonight. But I want to offer more profound thanks. In the acknowledgments to your book, you wrote, one of the theses that I set out to prove in this book is that a popular audience would be interested in a book about the more technical sides of the Supreme Court's workload. Thank you. Thank you for having that faith, and thank you for having the courage of your conviction. Consider, for a program sponsored by the Berkshire's chapter of the Osher Lifelong Learning Institute. 872 people registered. So to every cynic who thinks the public won't understand or won't care, take that. To our audience tonight, thank you for joining us. If the activities of the Supreme Court are of interest, I urge you to sign up for Professor Vladeck's newsletter, One First. It's for lawyers and non-lawyers alike. Believe me, the free subscription is great. Even better, the modestly priced paid subscription. If you do either one, do it, and then I will have just 2 words for you. You're welcome. As always, thank you to Ali for hosting this program and programs like it. If any of you watching are not Ali members, let me say, if I had the power, I would order you to do something about that, but I would not do it on the Shadow Docket. I would sign my name and I'd give you my reason. And the reason is these free programs do not pay for themselves. Ali requires financial support. Go to berkshireali.org. Please do the right thing. I want to conclude by quoting 2 great American lawyers. First, the great Clarence Darrow. Darrow said, "I have suffered from being misunderstood, but I would have suffered a hell of a lot more if I'd been understood." I'm hoping that Professor Vladeck is understood and that he and we benefit accordingly. Professor Vladeck is my second great American lawyer tonight. He gets the last word from the penultimate paragraph of his book, where he writes, "It is no exaggeration to say that in the months and years to come, as courts become the battlefield for fights over voter suppression laws, election integrity disputes, and perhaps even the legitimacy of future election results, democracy itself may depend upon a Supreme Court widely perceived to be legitimate. While the alternative to a legitimate court may be satisfying in the short term, it will end poorly, not just for the justices, but for all of us. That is why it is incumbent upon the Supreme Court to bring more and more of its work out of the shadows, and it is incumbent upon all of us to understand the increasingly grave implications for our republic, if and when it does not." I hope tonight has played at least a small part in that process for all of us. See you around campus. Good night.